Hello, this is Matt on the Moon Family Sedan channel. The SEC has finally expanded upon a theory from the SEC v. Ripple case that they put forth, which has become known as the embodiment theory. And the embodiment theory is this idea, effectively, that every single XRP transaction from the beginning of time up to this point and spanning out forever into the future, no matter what, represents the promises and efforts that Ripple made. Therefore, secondary market transactions, everything touching XRP, illegal, unregistered, secure, investment contract. It's a nonsense argument, and I've mentioned a few times recently, because it keeps coming up, that when they put forth this theory, when they filed their legal brief, they make this assertion, but what is noticeably missing is a footnote citing case law. Because they literally just made it up and said it. It doesn't make a damn bit of sense. Well, check this out, and this is going to be incredibly interesting. So the other day, the SEC filed their opposition brief in the Coinbase lawsuit, and they expand upon this theory. And my God, they're doubling, tripling, quadrupling down, and I don't think this is going to go well for them. It doesn't make sense. It's an incoherent concept. But I've got perspective from attorney Jeremy Hogan, attorney John Deaton, and they definitely do not share the same perspective as a former SEC attorney named Mark Feigel. And this guy, I've been highlighting him on my channel because I think he's operating in good faith. I find that I typically don't agree with him. I just don't think that the way that he's applying logic makes as much sense as what attorney Hogan and attorney Deaton are saying. And fine, I'm biased. Hopefully that's not bleeding too much into my analysis because I want to live in reality. But I really think that attorney Hogan and attorney Deaton just have the better arguments. And it's going to be fun, though, because I love the thoughtful discourse. I'm a big fan of debates in general, as long as it stays civil. If it's not civil, then it's not a debate at that point. It's just an argument, and those are kind of stupid as hell at times. But this is going to be an interesting one. I'm going to share with you the arguments, latest comments from all of them. But yeah, Hogan and Deaton definitely versus former SEC attorney Feigel. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so this opposition brief filed by the SEC the other day, it's several pages long, but I'm going to hone in on just a couple of the most relevant and interesting parts here. You'll see that what they're arguing here in this Coinbase case, it's an expansion of what they've argued exactly in the SEC v. Ripple case. So they're going whole hog with this nonsense argument. What a novel idea. It's trash. They're just making crap up. And there's no way that this stuff is protecting investors anyway. So anyway, let's look at the bottom of page 2 here. And I think, yeah, that this is the part where I wanted to jump in. The SEC wrote the following. Coinbase cites no case in support of its assertion that secondary market crypto asset transactions are exempt from the federal securities laws, and for good reason. Courts, starting with Howey itself, routinely look past conclusory assertions that a sale constituted nothing more than the sale of an asset and consider the totality of the facts and circumstances to determine whether the transaction involved a security. Okay, so upon reading that, I just one of those facepalm moments, and I'm like, isn't this rich? So they're arguing that Coinbase didn't provide a footnote, let's say, stating where a court found that there was a specific decree as it pertains to secondary market transactions. Well, that's pretty funny, because when they put forth the embodiment theory in the SEC v. Ripple case, the SEC didn't apply a footnote on this. So they didn't do it, and now they're just saying, hey, look, Coinbase, they didn't cite case law here. Well, here's the thing. When it comes to the secondary market transactions, you remember that big old document from attorney Lewis Cohen? It's almost 200 pages where he went through painstakingly every single case dating back to the beginning of Howey, and found that there are no secondary market transactions that have been considered extensions of the initial transaction and investment contract. Remember that whole thing? So that's the precedent. The precedent exists. It's not the case that it needs to be asserted by a court that secondary market transactions aren't so on and so forth. You don't need that. because they're, in fact, see, here's the thing. Coinbase, like, they're on the receiving end of this. It's the SEC that is putting forth the bogus embodiment theory assertion. And so the onus is on them to provide a footnote, not Coinbase in defending and citing case precedent. No, the onus is on those asshat pricks at the SEC. Clearly, that's how logic works. I'm not an attorney, I just play one on YouTube, but I'll tell you what, you don't have to be that smart. You just have to apply logic. You can figure this stuff out. There's one more part I wanted to highlight, and then I'm going to get into stuff from Attorney Hogan right away. It's starting right here. They also wrote, so there's a little bit of a break. I don't want to read the whole thing. I just don't think it's necessary. It's on your screen if you want to. You can pause. But the SEC then says, slightly later in the paragraph, nor is there any reason to alter this analysis simply because an initial investor in an investment contract resells the asset to a subsequent investor. Indeed, in the context of the transactions at issue here, the economic reality for those who invest in the secondary market is the same for those investors who buy crypto assets directly from issuers. So there you go, folks. If you buy XRP from me, if I were to sell it to you, that's no different than if you bought it directly from Ripple. Think about that. They're sticking to this. This is the epitome of absurdity. And then they state, the representations made by crypto asset issuers and promoters and investors, reasonable profit expectations, do not disappear merely because an asset can be resold or purchased on a trading platform. Okay, so let's pause to think through this then. If it doesn't disappear just because of that, does it ever disappear? Has the SEC provided any sort of guidance or clarity surrounding this? Because they're making these assertions. Well, the answer is no, obviously. And so, really, this is the recognition, an observation of a particular gap in the law, wouldn't you say? Yet Gary Gensler still pretends, he said, everything's so clear, everything's so clear. Well, hell no, it's not. So there's an XRP community member named Steven, and it ended up being his thread on this exact topic, where he was noting that, this is an expansion, effectively, of what the SEC has been saying about secondary market transactions in the Ripple case. And this is ultimately where Attorney Feigel and Attorney Hogan and Attorney Deaton had some stuff to say. But first, I'm going to share with you what Attorney Hogan said in his own thread the other day. He wrote the following. The SEC's Coinbase opposition brief, just like in the Ripple case, tries to run away from the state blue sky laws, which predated the legislation establishing the SEC. Problem is, the Howey case itself explicitly pulls from and states that the state case authority is relevant. Okay, so the reason that this is important, and by the way, I actually mentioned this first, when we're talking about blue sky laws, just know that what we're talking about is the fact that before the SEC, there was no sort of federal regulation on this topic, so this, of course, obviously predates the Howey test and even the SEC here. And so what was going on is there were individual states that were basically creating their own precedent, but literally on a state-by-state basis. And I think it seemed to me that, like, from what I'd read anyway, I don't think I'm misunderstanding this, somebody can correct me if I'm wrong, but my understanding is that, in one state, if there's a particular case that popped up, they may look at what another judge was concluding in another case. So even if not technically binding on some sort of federal level, it seemed, my understanding is that it's a case that judges were kind of looking to what other judges have done for guidance, which doesn't sound wacky in the least. But when we did ultimately end up with the federal regulation after the SEC did what it did, well, understand that came specifically from the state laws. So again, when we're talking about blue sky laws, just understand we're talking about individual states. So what Attorney Hogan is noting here again, he says, quote, the Howey case itself explicitly pulls from and states that the state case authority is relevant. Okay, so all these individual states came to their own conclusion, and even in 1946 with the Supreme Court in the Howey case, they're saying those conclusions, that precedent from the states, it is relevant here, which is unfortunate for the SEC because you can't have an investment contract without a contract. That's what was found when you're referencing the blue sky laws. You can't have an investment contract without a contract. And I don't know about you, but I don't have a contract with Ripple. Do you? I'm going to go ahead and hazard a guess. No, I'm going to guess that you don't. So then separately, Attorney Hogan responded to XRP community member Steven, and Attorney Hogan said, and I love this because this just crushes it. It absolutely crushes the argument. He says, the SEC's argument is simply counter to what the law says. The SEC chose to label these sales investment contracts, and so you are under Howey, which requires a case-by-case analysis. If the SEC wants out from under Howey, then come up with a new theory or get the law changed. So there you go. So we know that what the SEC is arguing, if we want to be polite, and I don't really want to be, but you could call it a novel theory. I mean, I just think it's horse crap. It's complete and utter garbage. So, because again, you know, since they're calling these transactions investment contracts, that means that the SEC must adhere to Howey, the Howey test from 1946. That requires a case-by-case analysis. But what do we see here? Is the SEC engaging in a case-by-case analysis? Or are they just saying, hey, even secondary market transactions, just in a general sense, they just are. They just are this thing that we're asserting that they are. Illegal. How? That's not within the confines of the law. Like, this should be, this argument's over. Like, it really should be here. I just don't see how this is going to stand up in court. I really don't. But former SEC attorney Mark Feigel feels differently. So I don't find his argument persuasive, but I love to share opposing viewpoints on the channel here. So here's what he said. I personally believe this is absolutely correct. And he's referencing, again, let's pause a note for those who not, he's referencing what the SEC argued in their opposition brief in the Coinbase case. Just the other day. So he's in agreement with the SEC, and he says, I personally believe this is absolutely correct in terms of policy and the intent of the securities laws. Whoa, hold on. It's the intent. Okay, so it wasn't stated. There's nothing in terms of case precedent, and Attorney Hogan pointing out what he pointed out, that you got to go on a case-by-case basis, but it was the intent. There's no case precedent. There's nothing that you can really point to, but that was the intent. You just know it, right? You feel it in your heart and your soul, right? That was the intent. And this is kind of at the heart of what Attorney Feigel's actually arguing here, just that one sentence. He flushes it out, so I'm going to share with you what he said. But I read that, and no disrespect to him whatsoever, because I think he believes what he's saying, so far as I can tell. But I got to admit, I was kind of rolling my eyes a little bit. Oh, it was the intent. So we're not worrying about the precedent here, or anything like that. So anyway, Attorney Feigel again says, I personally believe this is absolutely correct in terms of policy and the intent of the securities laws. Whether it's supported by precedent is another story. So pause. He's acknowledging, okay, in terms of precedent, do we have it? Okay, but it's the intent. Well, does that override everything else then? Because if you're the SEC, the answer is yes, unfortunately. They'd say, yep, well, hey, we just want to argue this thing. It's the intent, because it was the intent of the law. Oh, okay. Well, why didn't the judges say that in 1946 then? And then Attorney Feigel says, I think it's a novel issue that can go either way, and disagree with those who argue the SEC is overreaching. Yeah, so as far as the SEC overreaching, I respectfully disagree with Attorney Feigel here. I think there's been gross overreach. We're going to circle back to that, though, because Attorney Deaton actually tackles that. So let me go through this in a particular order, though, because it'll flow best this way. But Attorney Hogan responded to Attorney Feigel, and he just kind of asked him a question, which isn't so easy to answer if you have the perspective that Attorney Feigel has. But anyway, Attorney Hogan says, Mark, if the sales scheme somehow makes the token a security in perpetuity, would you agree, from a logical standpoint, that if the sales scheme does not make the token a security, it is also not a security in perpetuity? And that latter situation makes no sense. So you see what he's saying here? The idea, because, again, the embodiment theory, it's that, because of Ripple, all the transactions, everything that's happened in terms of adoption, from the beginning of time up to this point in time and forever into the future, it's all because of Ripple. It's the embodiment, right? That's what it is. So if what Attorney Hogan here is saying is if a token, so say it's XRP, is going to be security in perpetuity because of that, then if there isn't a sales scheme that makes the token a security from the beginning, then is it also in perpetuity not a security for that reason? Now, obviously, I know why he's asking that. It's because that doesn't make logical sense. That's the point. because it's in reality, it's about how an asset is actually packaged and sold. You have to look at individual transactions, the totality of a scheme. That's why he's asking that, because Attorney Feigel, I just think he's off base. I don't find the arguments compelling here. And so then Attorney Feigel did respond, though, and he said, yes, I'm assuming the original offering involved a security, which isn't to say a commodity can't later be securitized, but that's an even more complicated situation we're not facing here. And I'm not saying it's necessarily a security in perpetuity. I appreciate that a token's utility may take it out of the ambit of securities regulation. Pause. That sounds like the Hinman speech, the Ethereum Free Pass speech, June 4th, 2018. Remember that little thing? Because part of what Hinman argued was that, Ethereum being how it is, this current state of decentralization, well, there you go. It shifted into not being a security. And so here, Attorney Feigel is saying, well, okay, so if something is going to, for some period of time, be a security because of whatever the issuers did or the original creators, well, maybe it doesn't stay like that. Okay, except for that's not what the law says. See, this is the thing. I have long stated that, if you want to clear this up and not completely throw out Howey, you probably don't have to. You just need some additional guidance. If we're going to go this route of, is something so sufficiently decentralized that you can't blame just a developer building on top of something, then set the damn criteria. But that's not today what the existing law. It just isn't. And so he's saying here again, that it's not necessarily a security in perpetuity. Okay, well, you're just saying stuff though. That's the thing. And then Attorney Feigel says, for me, the question is, if the initial offering involved a security, is the burden on the SEC to prove each successive sale also involves a security? Or is it on the seller/exchange to prove the token has morphed into something else due to utility or whatever? Here's where I think the law is unsettled, and I think both sides have an argument. Okay, well, look, I don't think there's sufficient clarity. I would agree on that point. But he's saying is the burden on the SEC to prove each successive sale involves a security? Yes, it literally is. If you're calling something an investment contract, as pointed out by Attorney Hogan, yes, that literally is the case. So I just, again, respectfully disagree. Here's where Attorney Deaton jumped in. He wrote, Mark and I agree on some things, but arguing the SEC is not overreaching isn't one of them. It would require one to ignore everything we've witnessed and heard coming from the SEC since 2017, including the DAO, the 2019 SEC Framework for Digital Assets, the Hinman speech and emails, letters and speeches by Clayton and Hester Peirce and others, confirmation hearing testimony by Gensler, etc., etc. In my opinion, arguing the SEC isn't overreaching requires one to ignore all of those things and assume the SEC is acting in good faith, guided by the mission of investor protection, and is seeking to apply the securities laws to a gray area, considering there is no legal precedent regarding secondary sales it can hang its hat on, and is thus allowed to apply a novel embodiment theory that the token itself represents the investment contract. I'm unable to ignore the last 6 years of inconsistent and bad faith behavior by both SEC enforcement lawyers and the leadership of the SEC. As for the library reference, what the SEC cites is not consistent with what Judge said during the January 30th hearing, where he did make a distinction. Hopefully, and by the way, so he's talking about obviously, the remedies portion where Attorney Deaton was representing Naomi Brockwell as amicus. The judge did differentiate between secondary market transactions and his ruling where library did break the law from the judge's perspective. And so then Attorney Deaton says, hopefully soon he makes a ruling consistent with what he said on the record. For example, how he made the distinction that just because he ruled that when library sold LBC to Flipside Crypto violated the law, doesn't mean when Flipside sells it to Coinbase or anyone else also violates the law. If his decision isn't out before Coinbase's reply brief, if I was Paul Graywell, that's Chief Legal Officer of Coinbase, by the way, Paul Graywell, I would cite the January 30th hearing transcript. Spot on. I think he absolutely nailed it there. How could you possibly believe that the SEC is operating in good faith? How could you possibly believe that they're not overreaching? So it is what it is. I'm biased, obviously. I'm definitely biased. Attorney Mark Feigel, though, used to work at the SEC. He's got some sort of bias there, so we're all tainted. But I gotta say, I'm being honest. I really believe this. If I came in with a blank slate and you present both sides, I really firmly believe if I didn't have a dog in the fight in terms of holding XRP or crypto at all, I gotta believe that I would still find Attorney Deaton and Attorney Hogan to have the much more persuasive arguments. Like I'm trying to pull myself back from this and be like, okay, I get it. I want so and so to be the case. I want this thing to end. I want Moon and Lambo, all that crap, just like you guys do. But when I try and just do my best to make sure I'm staying grounded in reality, I can't imagine that I would think differently even if I came in with a blank slate here. So is what it is. That's the update, though. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.